Some contracts can be like a clock, with many interwoven parts that depend on each other for the entire operation to function as intended. To figure out how one piece moves, you need to look at the whole. In Rather versus CBS Corporation, we'll explore how contract provisions interact to determine what CBS's contractual obligations were when removing Rather from his position. Dan Rather was a news anchor on the CBS Evening News. Under Rather's employment agreement, if he was ever removed from his anchor position, CBS was required to assign him as a regular correspondent on the show 60 Minutes 2. Or failing that, except as otherwise specified, it was required to terminate the agreement, release him to work elsewhere, and immediately pay him the remainder of his compensation through November 26, 2006. The contract then went on to include a pay-or-play provision, where CBS wasn't required to use Rather's services or broadcast his programs, and was only required to pay him his usual compensation. After narrating a controversial 60 Minutes broadcast involving President George W. Bush, Rather delivered his final broadcast on the CBS Evening News on March 9, 2005, before being nominally assigned to 60 Minutes 2 and later 60 Minutes. Although CBS kept Rather at his usual pay, it no longer had him cover important news stories. CBS didn't terminate Rather's contract and release him until June of 2006, at which point his compensation was accelerated, with the remainder of his salary under his contract being paid. Rather sued CBS for breach of contract and breach of fiduciary duty, among other claims, in a New York Supreme Court. Rather argued that he should have been paid for the remainder of his contract in March because CBS didn't broadcast his content. CBS moved to dismiss the claim for breach of contract, interpreting the contract to mean that subparagraph G, the termination provision, modified the pay-or-play provision to require that Rather also be utilized if he wasn't terminated. The trial court denied the motion. CBS appealed to the New York Supreme Court Appellate Division.